has arrived or plans on coming, for that matter.
What are we on now?
Subpoena was served.
What is this number? It's set for creditors exam.
This is debtor's exam, yes.
Oh, that's Miss Lewis. Okay. All right.
Whoa, hold up. Sonia just said she didn't even know she had court until the night before. That's either a major miscommunication or someone dropped the ball big time. Can you imagine finding out you've got court the next day? Let me know in the comments. Have you ever had a last-minute scramble like that?
And she's not appeared. I thought I had issued a default on this. She's not here. All right. So what I typically do in these cases is that then I will issue an order to show cause. From that order to show cause, then I would issue a bench warrant if she doesn't appear.
Okay, sounds good, Your Honor. I have a question. Can I approach the bench?
Yes, you can. I did say so on the record. We'll set it for June 2025, 9 a.m. Court calls the case of Cross Street Properties versus Garrett Davis.
Good morning, Your Honor. Parista Gazari appearing for plaintiff.
Garrett Davis or Luke Hanna?
Your Honor, we actually resolved the case as to defendant Hannah and dismissed that party only from the case.
The old cash for time extension handshake deal. $50 under the table to stretch the move-out date. Classic. But here's the thing. Verbal side agreements like that don't always hold up in court. Thankfully, this judge seems more focused on resolution than rigidity.
Case.
You see that?
So today we're seeking to proceed as to defendant Davis. I filed a motion for entry of default judgment as to that defendant. Notice of the request for entry of default judgment was served at least 7 days before the requested entry today in accordance with MCR 2.603 B1B. But just so the court is aware, the motion was filed 8 days before today.
Got it.
So that it's clear. But he has not appeared. This case started as a summary proceedings for possession and money. Then defendant subsequently moved out. We amended the complaint to add money damages. There was extensive damage to the property. And here we are.
And you're requesting a judgment in the amount of $8,093.
No, Your Honor. Actually, the amount has increased. So the property has not been re-rented. It has been listed, but it has not been re-rented right now. The total amount of damages is $16,111.42. There's court costs of $397.10. The statutory $75 attorney fee for a total of $16,583.52. And that is after application of the security deposit.
That's after the
Yes.
Okay. All right. Garrett Davis, hearing no response based upon the motion that has been filed, as well as the indication from counsel, court will enter a judgment as requested by default.
Thank you, Your Honor. I will submit the judgment electronically.
All right, very good.
Thank you.
BMC Rio versus Netty Whitlock.
Good morning, Your Honor. Ian Redmond, P70599 on behalf of the plaintiff.
And greetings, Your Honor. Emmett Greenwood on behalf of defendant P56556.
Okay, good morning.
Your Honor,
Yes.
a new bankruptcy was filed yesterday afternoon, so we are not looking forward to doing anything today other than informing you of that bankruptcy.
All right. So what I will do is I will administratively close the case and pay the man.
And then if and when this reopens, we will do the same thing that we did a couple weeks ago.
So great, you'll be back, huh? No, go ahead.
Well, no, Your Honor. This would court entertain my motion to withdraw from this case.
Yes, I mean, if you file an order with the court, I'll sign an order of withdrawal.
Okay.
I
It
have
has
no
nothing-
objection at
right.
all. I would say that since this is administratively closed, depending on what the engagement was, the engagement may be terminated as of right now.
Right, but I think what would happen Well, I don't know, because do we have?
I'll just submit
We have counsel
order.
listed.
We do have Mr. Rio listed.
All right,
I'll submit
so
order.
submit an order to
Okay.
that effect. All right, thank you.
All right, thanks.
Sycamore Meadows versus Autumn Meadow.
Good morning, Attorney Carrie Green. This is Sarah.
Good morning, Your Honor. Emily Brule, PA827, defendant.
All right,
Judge, I did give counsel updated ledgers this morning. I got them late yesterday, so I did hand for that and any of the research that we have that they requested.
all right.
So, Your Honor, Ms. Meadows was told by the Sycamore front desk that she should just hold on to her money orders until they got things straightened out. So now that we know that things are on their way to getting straightened out, she just needs to give her money orders for the past couple months, get a fresh ledger, get that ledger to emergency housing fund, and we should be able to get this all resolved.
Okay,
On the pathway to the finish line, Judge.
halfway to the finish line? Okay. As long as we keep running in that direction, we'll be good.
Judge, agreed. And I apologize to the court. Obviously, it's not me, but I do apologize as I'm standing here representing them. And we all know I don't like being in.
No, I know, and it's a process, right?
For sure.
So you guys need a date out.
I think at least 3 weeks for
That's
everything.
fine. I'm good with that.
Will June 10th work?
Works for me, Judge.
All right. So I'll adjourn this to June 10th. 2025 at 9 a.m.
Thank you, Your Honor.
Then Sycamore Meadows versus Derek Hall.
So, Emily Brule for defendant.
And Attorney Carrie Green on behalf of plaintiff, Your Honor.
Mr. Hall has moved out. We do, however, have counterclaims, and so we would like that to be transferred to the civil docket. We're also waiting for hopefully a resolution.
Well,
of that.
that'd be transferred to what? The civil docket?
That was my understanding of what would happen.
I don't know how that's the thing. I guess we could bifurcate the possession if he's vacated.
Well, the civil docket would normally be handled by Judge Barr. This is not going anywhere.
Okay.
So if you want to call it the civil docket, call it the civil docket. I don't care. So you still have your counterclaims.
Yes, and our concern is just for protecting defendant's credit, getting that down to a number that he agrees to, and then he will pay.
You send me a number.
I did give, but yeah, I will.
Will you send?
I will send everything.
Okay, send me a number and I'll take it to my client. Judge, hopefully we'll be able to resolve this.
June 10th, 2025, 9 a.m.
Thank you.
Sycamore Meadows versus Vernon Jantz Jr.
Again, Carrie Zanon on behalf of plaintiff. I'm actually handling your court officer assigned conditional dismissal on this one. It's my understanding Mr. Jantz is going to vacate by June 10th. Both parties have signed that.
That's correct, Joe.
That's correct. Since counsel is on this. This case is conditionally dismissed. They've signed that. Sycamore Meadows versus Curly Fulton.
Emily Brule for defendant.
Carrie Zanon on behalf of plaintiff.
So for this one, we do have some concerns with the ledger. I did not know that plaintiff was going to have updated ledgers, and so I am not prepared to argue everything. I apologize to the court for that.
Judge, I'm okay with June 10th on this one, if that's okay with you.
So I just want to make sure where we are on it. You got the updated ledgers
Yes.
now, and you think there are some discrepancies.
Yes, I believe there's a 1420 overcharge.
1420, are you saying 1,420, or are you saying $14.20?
1,400.
Okay.
Oh, because if it's the 14, I.
Because if it was
that-
1420, Alan would pay it. No.
I would pay it now.
Okay.
Alan doesn't need you.
Oh, okay. All right.
I didn't know Alan provided rental assistance.
No,
Neither
No.
did Alan. actually.
sometimes I just spend his money. It's just the way it works. Okay. So June 10th.
Please.
All right, I'll adjourn this at June 10th, 2025, 9 a.m. Thank you. All to the bank of Felicia. Sycamore Meadows versus Clarissa, is that how I pronounce it? Nichols.
Emily vote for defendant.
Carrie Zan on behalf of plaintiff.
And for this one, now that we have a ledger, we just need some time to get into it.
Okay. June 10th, 2025, 9 a.m.
Thank you.
Sycamore Meadows versus Kala P. Kayla P.
Good morning, Your Honor. Jill Bauer on behalf of Ms. P, who is also present.
Ms. P.
All right, where are we on this?
As we have the motions, I believe, up today. I filed a motion for entry of judgment. I know that you've read them.
Yes.
And I know that counsel filed a response to my motion for entry of judgment. She also filed a motion to dismiss as I filed a response as well. I know that you've read everything, unless you have any questions. The only thing that I would briefly say is that two things as to the health hazard that they're playing. Well, Judge, I don't know how you want to do this. I guess I'll stop talking and leave that part to you. And,
No, go ahead.
Judge, my motion for entry of judgment is no triable issue. Partly that is, the things I wanted to add is the arguments that they're making in their response and their motion to dismiss are legal arguments. So as to the jury trial, I don't believe that any of this is a jury triable issue. I think this is an issue for you to decide, whether it's in our motions or whether it's at a trial. So I wanted to put that out there first, because I truly believe, going over everything that has been filed, that's where we're at. As to the argument as to the health hazard, they claim that the health hazard was improper and it should have been a different notice. I would argue that where HUD is silent, state law trumps, and that's what this is at this point. And then the only other thing I wanted to add is the health, the 7-day was never cured. They had a chance to cure, and that's why we're standing here, because it wasn't cured. And I think that's all I have to say at this point.
I just want to make sure, I thought we were going to ask if.
Oh, do you want to do that first? Oh, I didn't know.
We talked about asking if you wanted to speak with us in the back
and I'm still agreeable
more fully, but.
Sorry, when you said you wanted him to rule on the motions, I figured you wanted that first, but if you wanted to talk first, I'm good with either, Judge.
What would you prefer, Your Honor?
Poor Judge.
I haven't said a word.
You called the case, Judge.
I did. So why don't I do this? Let me pass it. I'll talk to the two of you back.
Okay. Thank you.
Miss Bauer could have stopped you at any minute, but she just didn't. And then she goes, but I thought, no, never mind.
Well, I wasn't sure if you were winding your way to that.
Winding? Wow.
Oh, is that
Jill, that's why I go straight in.
That's right. That's right. She's winding into that.
Sorry.
All right. Court recalls the case of R&J Group Holdings versus Saffield et al.
Plaintiff is ready, Your Honor.
Counter plaintiff is also ready.
All right. Where are we on this, folks?
Good morning, Your Honor.
Good morning.
God bless you, Your Honor.
I have tried to figure out exactly where our posture is on this case, because I received 2 emergency ex parte motions. You have those, counsel? Pardon?
No, I received one some time ago for an adjournment that's long since come and gone.
No, these were filed yesterday.
I have no such, I haven't been served with anything. I had no idea those were even in existence.
Oh, and I'm trying to figure out, why are they ex parte? Why is the request ex parte?
Permission to speak, Your Honor?
Yeah.
Okay, good morning. They are ex parte because the order that Your Honor signed for $5,000 a month bond escrow, we are trying to revise that to $250,000 refinancing proceeds of another property.
Is this case currently before the circuit court?
It is currently it's been appealed. Your Honor's judgment has been appealed, and we filed a motion to dismiss the appeal. It's still pending, but that's all I can tell you about that, Judge.
So we'll get copies of these to you, but that's what it, I mean, I'm not clear I understand these motions, because the first motion is to have a lending institution. You want the bond changed from 5,000 a month, which was the escrow order,
Correct.
to customarily then become your bond on appeal. You want